Good morning, everybody. I think that's everybody now. Yeah. Not missing anybody, are we? I don't think so. Okay, well, good morning, and I want to thank you all again for your participation this week. I think we could probably, in terms of time, will conclude today. But I want to make sure that by the time we conclude, that everybody feels comfortable that any questions that they have outside of the sequence that we've been following, you've had an opportunity to get to ask or get your point across. And so I thought what would be appropriate today, the order of business. We wanted to start, the panel members wanted to start by asking our council to make a statement. And following that statement, what I would like to do is pick up from yesterday. We concluded with Government of Nunavut's presentation and on behalf of Government of Nunavut. And I'd like to have an opportunity for responses to that, if there are some, from QIA and Baffinland. And then I wanted to, if you're in agreement, I wanted to have a period of time where we can ask any questions that may have arisen from anything this week. I've got several that I'd like to ask from the presentations that were given. And then if you have anything to add. And then I thought it would be appropriate to deal with the whole issue that was raised on jurisdiction. and then we can conclude. Does that order seem fair to everybody? Is there any comments on that? No? Okay. So we're going to start then, and I'll ask Kirk. I'll ask Kirk to make a statement of Tribunal Council. Go ahead, Kirk.
You're on mute, Mr. Lambert.
Thank you. Good morning. I would like to address an issue raised by counsel for the parties concerning the manner of my questioning earlier in this proceeding. My intent is to mark this statement as an exhibit in the proceeding. I apologize that the manner of my questioning caused concern. A matter of procedural fairness arising from the conduct of counsel for the tribunal should not blemish the record of this tribunal in this proceeding. In reflection, I believe my use of leading questions to frame a point was futile, as I should simply have expressed the point. After the pre-hearing conference, counsel requested advance notice of questions I would ask during the hearing. I responded that I was not able to do so because my questions were still in preparation and that work would not conclude before a consideration of each counsel's submissions at the hearing. Earlier this week, counsel asked for the opportunity to respond to the point of my earlier lines of questioning. That point is subsumed within the procedural proposal sent to you by the panel yesterday. The panel has waived solicitor-client privilege in respect of the matter of legal advice, respecting its obligation to decide these appeals, and has asked me to make this statement to you. At all material times, legal advice from panel counsel to the tribunal, its members, and the members of this panel has emphasized that decision-making authority resides solely in the tribunal and its members. The obligation of panel members to decide was covered in training referenced by the chair in remarks earlier in our proceeding, provided by Alberta's Foundation of Administrative Justice, and has been repeated in legal advice provided at all times since. I act under direction from the panel. Thank you, counsel.
Thank you, Kirk. I would like to move on now to if there's responses to the government of Nunavut's presentation put forth by Jane O'Neill and Ryan Baxter. And I'd like to comment again, that was very well done. All the presentations at this hearing have been excellent, and obviously reflects a lot of work and all of your expertise in your field. And as a panel, we've been very appreciative of how well done those have been, very well laid out arguments. But having said that, I would ask if there's any questions and I'll start with QIA, that you would like to make or respond to the government of Nunavut's presentation.
Yes, thank you, Chair. And I'd also like to thank Mr. Lambrecht for his statement. That's appreciated. We do have some brief reply submissions. I agree, it was quite helpful to hear in particular GN's interpretation of Article 22, which was stated, their written submissions were clear on their interpretation. I think yesterday my friend Ms. O'Neill was quite clear as to their interpretation. What I heard and what you heard yesterday was that the GN's interpretation of Article 22 is that it's fundamentally a wealth redistribution scheme. It's a scheme that allows the government to tax Inuit-owned land throughout the territory to fund government services in other localities, even lands well removed from Inuit-owned lands themselves. Now, I can see that there's a certain attraction to that kind of scheme. It provides the government perhaps more stable finances, provides the ability to impose taxes on lands where they don't provide services and improvements. There's a cost efficiency in that. But I really want to emphasize what I think we said in our written submissions. The task is not for this tribunal or the government of Nunavut to redesign a taxation scheme around the needs of government. Instead, what we have here is the Inuit's modern treaty. The essential task of this tribunal is to respect the rights and obligations that are set forth in that land claims agreement. It's to give effect to the scheme that the parties themselves negotiated. Now, I'll be frank about this. It may well be that the choices the parties made create additional burdens or inconveniences for government. I'd be very surprised, actually, if in a lands claim agreement, the purpose of which was to carve out land rights for Inuit, to reclaim an Inuit homeland, to set up a basis for economic self-sufficiency for Inuit through a land base. I'd be very surprised if the restoration of those Inuit land rights was terribly convenient for government. The point was to reorient the relationship between Inuit and government. Our overall position is that the terms of Article 22 do not describe a broad wealth redistribution scheme on a territorial level. Instead, what we've shown you, or tried to show you, is that the words describe a highly constrained taxation scheme when it comes to Inuit-owned lands and the property assessment and taxation. There are specific exemptions for Inuit-owned lands, and the definition of real property itself specifies a purpose. It specifies that taxes may only be imposed for local government purposes, for local government services and improvements. Overall, what I have to say is that those words, imposed for local government services or improvements, those were chosen to protect Inuit lands from precisely this kind of government incursion, from precisely this kind of government overreach. The point was that to establish a land base for Inuit that would not be subject to this sort of overreach. You'll recall I described some of the initial negotiating positions of the government and Inuit. The interpretation that the government of Nunavut puts forward is very close to the one originally put forward by government, which is we want very few fetters on our ability to tax Inuit lands. And I should clarify, my friend Ms. O'Neill yesterday said that she thought she heard the parties say that if you decide that these lands are subject to assessment and taxation, that it will mean that all Inuit-owned lands are improved or unimproved. That's certainly not our position. It's clear that non-improved Inuit-owned lands cannot be taxed in the general taxation area. I have no concern about that. My concern is that if it's decided that these Inuit-owned lands in these circumstances, which again, the record is crystal clear, there is no local government in this area. There are no services or improvements even remotely located near these areas. If you decide that, yes, even those ones are subject to assessment, then every improved piece of Inuit-owned land in the general taxation area will be subject to improvement, regardless of whether the government has even laid eyes on it. The balance struck between the parties in negotiations was that if Inuit-owned lands derives a benefit from local government services, and I don't say that's a high threshold, there has to be some services in our submission. But the bargain was that if those lands derive benefit from local government services, Inuit-owned land should be available to fund those services. Certainly, that's fair. But where Inuit-owned land doesn't benefit, where there is no basis for imposing those taxes, in our view, that's consistent with the overall purposes of providing Inuit-owned title. The purpose was to restore their title, to protect that title, and to allow for a land base from which they could achieve economic self-sufficiency. So with that as a little bit of an intro, I do take issue with Ms. O'Neill's attempt to analogize between the taxation that may be imposed on land in Halifax, it was her example, and the situation that we have here. There's an analogy drawn between the taxation of that land in Halifax by the local government of Halifax for local services delivered in Halifax. Now, I take Ms. O'Neill's point was, well, for say her property in Halifax, there are a variety of services that maybe she fortunately has never had to use, perhaps the fire service she's never had to use, right? But there's still a benefit of having those services located locally. That's quite different than the imposition of assessment and taxation upon these Mary River lands, which would be expressly for the benefit of areas far removed from those lands. Now, I say this is a very good example, and there's two divergences, I think, between the interpretation put forward by QIA and BIMC and government on the other hand. The first, and I'll talk a little bit more about this, ordinary meaning, right? We've taken you through a very exacting exercise. Let's look at each of these words. What do they say individually? How do they modify each other? What do they say overall? What's the ordinary meaning? But perhaps reasonable people can disagree on the ordinary meaning of words, and that's why the test that we brought you to was not simply take your first impression and go with that. It was arrive at a first impression, try and understand the word local. Like, what is that word? What does it do in this sentence? How do we give it meaning? But then you have to go further. You have to understand the context in which this provision was negotiated and the context in which it's now in operation. The context here in Nunavut is totally distinct from the usual context that Ms. O'Neill brought you to, in which property taxation is normally assessed and collected. Here, we don't have a constrained taxation area like the municipality of Halifax, where land or property tax is collected by a body that necessarily can only provide local services. All of the property tax that is paid within a particular municipality like Halifax goes to Halifax. Halifax, like Iqaluit, for instance, is restrained in what they can do. They can only provide local government services or improvements. That's not the case in Nunavut, and that wasn't the case when this was the provision at issue here was being negotiated. While Iqaluit, that's very similar to their situation. There is also the scheme that was existing in PATA and that was created in the Nunavut agreement, is that there's also this general taxation area. And I think it's that context that really drove the parties to attempt to constrain the kinds of taxes that could be imposed, the circumstances that would justify the imposition of tax. As I mentioned, and Mr. Maley, you raised a question for my friend yesterday about, well, PATA existed at the time. Does that mean that we can use PATA to help interpret the agreement? My point and pointing at what PATA and the NWT said at the time was merely to state the parties in negotiating this agreement, they had a model of property taxation that did not contain any of these constraints on what a tax could be imposed for. They could have just used that, and they didn't. That's my point there. The context in which they were negotiating, though, was there's a large general taxation area. There are not going to be municipal taxing authorities in each of the towns, villages, hamlets that exist in Nunavut. There's going to be a central government that collects those taxes. Services will be delivered by municipalities, hamlets, towns, villages elsewhere, but there's going to be a central government that's funding those things. How then do we constrain the government from attempting to tax lands that are far removed from many of those municipalities? I think that's the reason that that language was included in Article 22. They wanted to specify that while the central government, the territorial government, is putting on a hat of a municipal taxing authority, that it wasn't for all purposes, that they were constrained, that they had to justify why taxes were being imposed. Now, where does all this lead? Mr. Armstrong asked my friend Ms. O'Neill yesterday to clarify that, is what you're saying that local means the general taxation area? And that is GN's interpretation, that local in Article 22, which I've brought you to, it doesn't mean anywhere near the ordinary sense of the ordinary meaning of the word local. For them, it means the entire general taxation area. Our point in reply, they say local means the whole taxation area. They say local means everywhere. My point here is if everything is local, then nothing is local. GN's interpretation, even on the ordinary meaning of this phrase, it deprives the word local of its ordinary meaning. Everybody knows that local means something. I brought you to those submissions and I'll leave those with you. But I say it doesn't even deprive it of its ordinary meaning, it deprives it of any meaning. There's no reason for local to be in that phrase under GN's interpretation. I say that you should be rejecting that interpretation for both the reason that it doesn't give meaning to the words of the treaty, it doesn't give it its ordinary meaning, gives it no meaning, and additionally, it doesn't deal with the context in which this provision was negotiated. Now, counsel for GN on a number of occasions, I think attempted to argue that, well, yes, there's no local services that are offered at the site, but the GN spends money in a way that, as I took my friend Ms. O'Neill's submission, that really benefits BIMC. She pointed to, well, education programs, various other government services, health services that are offered that fundamentally benefit a workforce and provide a benefit to BIMC. It allows them to have their operations in effect. I took that to be really raising sort of a question of fairness there. Why is BIMC getting something for nothing? I'll leave it to my friend to make the point as they've made in their written submissions about, well, they're not getting something for nothing. There's a lot of other taxes, fees, royalties, et cetera, that they do pay, but I'll leave that for my friend from BIMC. But in reply, that's not the key question from my perspective. The key question is not whether BIMC benefits. The key question when you're looking at this article is whether the provision of local government services elsewhere benefits this Inuit-owned land. These lands were selected by Inuit very carefully to promote economic self-sufficiency. These lands were selected because of the Mary River, the potential for the Mary River mine to be developed in this area. Territorial spending that might benefit BIMC's current operation, it's not relevant to the interpretation of this provision. The only thing that justifies taxation in this area would be a benefit to Inuit-owned land through local services or improvements. And I have to step back to observe this. These Inuit-owned lands require local services in order to facilitate economic development. You've heard there are services at this site. There is water, waste, road maintenance, fire, ambulatory services. There are all sorts of local services that are required. These are the embedded costs of developing Inuit self-sufficiency through the use of Inuit-owned lands. But right now, they're being costs that are being borne by Inuit and by BIMC. The GN is not providing those local services that are required to run these sorts of operations. So GN provides none of the services. They don't support QIA and Inuit in developing these lands by providing those essential services. But they do show up at tax time, or they have for the last about 5-6 years. They do show up with an assessment for us. We say that's not the deal that was struck. My final point on the sort of the numbers here is GN has argued, as I took it, that it doesn't matter that the taxation that might be collected based on the assessments that are before you, it doesn't matter that it goes into their general coffers, where it's available to be spent on all sorts of territorial purposes. Ms. O'Neill yesterday said, well, look, we're only collecting this much in property tax and we're paying out perhaps more to provide funding to those municipalities to deliver local services. I believe she also mentioned some funding that for me probably ties equally to Iqaluit and elsewhere, but in any event, her point as I took it was, well, it's not like we're spending the money that we're going to collect from QIA on anything but local services, because we spend more on local services than we do in collecting property tax. Now, perhaps my point here is a bit obvious, but the assessment and taxation that they seek to impose on these IOLs would significantly increase their property tax revenue. Ms. O'Neill took you to the numbers of like the amount of tax that they're collecting each year in the whole of the territory of Nunavut. It's a relatively small number. It was under $10 million. The tax bills here, we took you to them in our presentation, well, would amount on the basis of the assessments that have been put forward, would amount to like about a 30% increase in that. It's actually a huge part. It would be actually a huge increase in the property taxation that could be collected. So what happens, Ms. Madden the other day, you raised a question about, well, what happens if there is more economic development on Inuit-owned lands? What if Inuit are successful in the longer term in establishing the economic base that was promised to them in the treaty, in part from using Inuit-owned lands precisely like the Mary River lands, remotely located, no local government in the area, Inuits with perhaps private parties fund everything. What happens in the case where there's more of that economic development? I think a reasonably foreseeable consequence is that the kind of taxes that the government of Nunavut could extract in their wealth redistribution scheme might well exceed the amount that's spent on local services. And it just arises from this. There is no internal limit on the GN's interpretation, like there is in Iqaluit. If there is Inuit-owned lands, let's just talk about a real example. Right now, Baffinland is proposing to expand and change its operations. That I'm sure is going to come along with new and additional improvements. Might well raise the amount of improvements that are at those particular lands. In GN's estimation, that would result in more taxes. The GN would be providing no additional services, no additional cost for GN, but their tax coffers become more full. At what point is the unfairness just manifest? These taxes were to be imposed for local government services and taxation, but there is no limit on where the government can spend those things. My final point in reply is to just in reply to something my friend Miss O'Neill raised. I just want to pull up a slide here if I could from my presentation the other day. Everybody can see that, I hope. So GN pointed out that there is an exemption for specific types of improvements. This is 22.2.4 that we brought you to the other day. So just to remind, Inuit-owned lands are only subject to assessment and taxation when they are improved. That's in both the municipal area, so there's a slight carve out in the municipal area, but in the general taxation area, only improved lands can be taxed. But there's a specific carve out for certain kinds of improvements that I say are really tied to Inuit way of life. The deal that was struck was improved lands will be taxed, but not all improved lands. Some improved lands we won't tax. The point Ms. O'Neill brought you to this section, and I think was trying to make an argument that this was a redundancy in the agreement. Redundancy is the wrong way to put it, perhaps. I believe the argument she was making is, well, this clause here wouldn't have much utility if you actually accept QIA's interpretation of the agreement. Because in QIA's interpretation, remote improved Inuit lands wouldn't be taxable anyways, where there's no government services. I think she brought you to this list and made the submission that, well, outpost camps, why would you need the language in a specific carve out if you would be accepting QIA's interpretation? Because outpost camps would be far away. I say there's no redundancy here at all. There is, and the GN submission on that point, I think, depends on an assumption that all of these sorts of activities that have a specific carve out would only take place far from areas where there is local government services that are offered. And I just don't think that's actually the case. There might be certain kinds of improvements, just pointing at outpost camps here, that might well be quite far away from any local services. But, for the rest of these, especially improvements which result from government public activity, fine. Any commercial structure associated with wildlife harvesting, non-commercial structure associated with other traditional activities, like that encompasses a lot of things. And, we can all think of a number of examples of things that would encompass, but really they're things that are built by people where people live. So I don't think it would be the case that other infrastructure built on IOL that's located near communities. And of course, there's extensive Inuit-owned land near all of the communities in Nunavut. So we say there's no redundancy between a specific restriction exempting certain Inuit improvements and providing what we describe as a broader exemption from taxing improved lands where no government services are offered. So I don't think you need to be concerned about that argument in our submission. And those are my points in reply. So thank you very much.
And thank you very much, Jeff. I'll ask our panel members if you have any questions related to QIA's response to the GN's presentation. Rick, any questions?
No, I don't have any questions.
Thank you. Paula?
I just, yes, I think that I have a question. I'm wondering about the term ordinary and the meaning of ordinary. And I want to ask if it is possible that ordinary is mediated in relation to many different things. So perhaps in this instance, location. So is ordinary, what is ordinary in Halifax also ordinary in Clyde River? I want to just get your sense of that.
Let me make sure I understand the question. Our submission, actually all the parties are in agreement on this, that you have a couple of sort of main principles you need to follow when interpreting this article. The first task is, what is the ordinary meaning of the words as they are used and the context that they're used within? So I'll repeat what I said a moment ago. I think it's possible for reasonable people to arrive at different ordinary meanings. And that's why you really have to do the rest of the work we've said, which is understand, really test your first impression as against the context of the agreement. But my overall point on the Government of Nunavut's submission yesterday is that Ms. O'Neill brought you to a dictionary definition of real property and of property taxation to say, look, this is just like the same meaning that's used in Halifax. There's nothing special about this provision. The language tracks exactly what a normal definition of real property is. I think she's suggesting that we're trying to make something out of nothing here. But the exercise that we've brought you through is, it's an ordinary meaning exercise. Let's talk about the meaning of each of these words. But I think the point that you really need to be attuned to, and I think it's a point that the Government of Nunavut doesn't spend a lot of time on, is what's the context in which this provision was developed? It's not that we have a specific small local area administered by a local government that's being provided a taxation power. The context of Nunavut is quite unique. I'll say, the southern provinces, the province that I'm in here, there is no part of the province that is where there is no local government. We have municipalities, we have regional districts that are a slightly larger area. Those regional districts and municipalities can collect taxation. Now, the flip side of that is they're specifically restricted in what they can do with those funds. They can only expend those funds for local government services or improvements within their specific regions. The challenge, I say, the negotiators were faced with was, geez, that's not the case in Nunavut. There are, it's a very sparse population outside of Iqaluit there are a number of municipalities and communities that are providing services to their community, but they're very small. And we can't impose upon those communities an authority to deliver assessments within their area and to collect taxation. That's a large administrative burden. So we're going to leave that with the government of Nunavut. But what was reflected in the definition of real property taxation, we say, is that we need to ensure that that grant of broader tax collecting powers does not grant the government of Nunavut carte blanche to do exactly what Ms. O'Neill suggests they can do, which is borrow from Peter to pay Paul, which is to look at Inuit-owned lands in very remote locations, tax those lands for the delivery of services far removed from those lands. The context of Nunavut demanded this kind of language to tie taxation to the purposes. Remember, it can only be imposed for those local government services or improvements. And we say to give deference to the words chosen by the negotiators, we really have to strive to give meaning to each of those words. And the word local there, it's not sustainable to say the word local means everywhere. Does that answer your question, Ms. Madden? Or have I gone off on my own tangent?
I think it does in part, and where it doesn't, I think I can extrapolate. Thank you.
Thank you, Paula. So
Chair, you're frozen for me right now.
about collectively, we'll talk about
Mr. Chair?
historic treaties and the manner in which they were done, and obviously lopsided to.
Mr. Chair, you were frozen before you
Oh.
began your questioning. Could I ask you
Okay.
to repeat, please?
Sure.
Thank you, sir.
So it's directed towards Jeff and or Aria. And in your presentation, you talked about historic treaties and the fact that they were done quite lopsided in terms of the historical context. But you also talked about modern treaties, and the benefit of modern treaties is that there's, obviously more professional advice and professional expertise given to those. So I'm wondering, and maybe your view is it is clear, I'm wondering why, when the Nunavut Final Agreement was drafted, the Nunavut Land Claim Agreement, and do you think it could have been made more clear in terms of IOL lands being tax-free for local, unless local services are, could it have been done clearer? I'm just wondering, we're at this point now where, we're trying to interpret what, why it was written the way it is. So in your view, could it have been done clearer, or do you feel it is clear? So I'll just give you an opportunity to respond to that. Thank you.
Well, dealing with the first question first, I think if you ask any lawyer negotiator to look at something they drafted a year ago, they will say, well, I could have done this differently. But that's not really the task, I don't think. The task is we have the words that are before us, and the courts have emphasized, particularly in the modern treaty context, we need to be very careful to determine what the meaning of these words are, given the broader purposes of the treaty. We need to have a very close look at this language, and we have the language that we have. And I say it is clear. The words of that definition are that there will not be tax or other assessment unless those taxes or other assessments are imposed for local government services or improvements, like including for schools and water. I think that I think it is quite clear, and I think that the interpretation the government of Nunavut puts forward for the submission I just gave to you, for the government of Nunavut, this provision doesn't exist. For the government of Nunavut, this provision just says can charge property tax under PATA, subject to the exemptions for non-improved Inuit-owned land that are set out. I say that if you're going to undertake the task that we ask you to, and that the courts have told decision makers to undertake, we need to be very careful to give meaning to that language. Could it be clearer? Perhaps it could, but this is the language that we have. And the inclusion of the words imposed for local government services or improvements, I think it has a very ordinary meaning that we can all understand. If I ask somebody in Halifax, what is a local government purpose, or what is a local government service or improvement, they do not start talking about services or improvements delivered in Cape Breton. Or in this case, it would actually be much further away than Cape Breton from Halifax. We need to strive to give effect to those words as we've presented to you.
If I could add one thing, I think this will have been clear, but just in case not, we don't look to context and purpose because there's a lack of clarity. It doesn't matter how clear it is. You always have to look at context and purpose. That's how the modern rule works, because sometimes there'll be a couple ordinary meanings and you need to make sure that you're choosing the right meaning. And that's what context and purpose does. And the modern treaty context, of course, that's just heightened because it's so important. And, I'll suggest to you, and I'll leave you with this thought, that the fact that the government of Nunavut really didn't take you to context and purpose isn't because their interpretation offers more clarity. It's because their interpretation doesn't accord with context and purpose. So they didn't go there. But it's not about going there. Isn't us saying, well, it's not very clear, so we need to look at context and purpose. It's just a necessary step in the statutory interpretation. And the benefit that I hope that we showed you is that the natural, ordinary meaning that comes from the words that it just says looks quite clear, ends up aligning really neatly with context and purpose, which kind of affirms that really is what the point was.
Okay, thank you both. At the risk of being repetitive, and the risk of putting you on the spot, Jeff, could you take us back to Article 22 and specifically to the argument on local? Can we just spend another few minutes on that?
Of course, yeah. Give me a moment to bring up some of my, let me bring up Article 22, and I'll bring up the section looking at
specifically the whole issue on local government services provided. That.
Yeah.
Yeah.
Sorry, I'm a little lost in my previous presentation. Let me just find that section.
That's okay. I sprung this on you. So you're right.
There we go. My apologies for the time that took. So, we, in our submissions, and you have our slide deck in the presentation, we have a series of slides here where we've tried to do what the courts have asked, which is go through with some detail what each of these words mean. And ultimately, they are words used in a sentence. So we need to understand what the sentence means. Is there a particular question you wanted me to address, or just you'd like me to sort of go back over that?
Yeah, so I just wanted you to review that one more time for me, so I'm clear, I'm crystal clear on your argument about.
Of course.
Yeah.
So we start here with the definition. This slide, what you see is we start with the word local. The comment that I brought you on Monday was we also have to look at the word imposed for. It's a little bit maybe pedantic, but the definition here is real property taxation means tax other assessments that are imposed for local government services or improvements, including for schools and water. I say that denotes an intention to say this is what would justify the imposition of a tax. And so what becomes really important is what is local government services or improvements? So we start with the word local. We've got a dictionary definition here. Like I get a little bit worried that this is almost too ordinary of a meaning, but local, everyone knows what local is. We contrast our definition of the word local with what GN says local is. GN and I think they were quite clear yesterday. For them, local really only means local government. And they say they're the local government. They're the local government for the entire territory. Again, I'll repeat what I said this morning. If local means everywhere, then nowhere is local. So we say, let's just give this local its ordinary meaning. It relates to a particular place. It doesn't relate to lots of places. It relates to a particular place. So next we say, what does local mean when it's next to government? Well, it's a local government. It's different than just government. I say to suggest or to accept the GN's interpretation would be to ignore that word local. GN has put a dictionary definition in front of you. We've got other dictionary definitions. And so to Ms. Madden's question a moment ago, are there different ordinary meanings of words? There could be competing meanings, but I don't think that there's any real dispute about what local government is. And when the Inuit negotiators were faced with inserting words into this agreement, people understood what local government was. There was local government in Nunavut. There was Iqaluit, there's hamlets, there's villages. They were there then, they exist now. I think it strains credulity to think that the Inuit or the Crown at the time would have said, well, that's actually a pretty broad term. That actually means a territorial government as well. So we say this denotes a particular form of government, and it's one that everybody knows. And the key point here is it's distinct from the territorial government. So then what does the term local government mean when it's next to services or improvements? Well, it's those services or improvements that are delivered by local government. That these local government services is different than just government services. These denote a particular class of government services or improvements. And they're those that are delivered by a local government, which is defined as being assigned to a particular area. It's those services and improvements delivered by that local government. The key point here for us is that these are restricted spatially. The local government of Halifax can only deliver services or improvements within Halifax. The local government of Iqaluit can only deliver services or improvements in Iqaluit. The local government of Clyde River can only deliver services within Clyde River. This I contrast very much with what the government of Nunavut is suggesting here, that this is a wealth redistribution scheme, that a local government service could well be removed in a very extreme sense from the lands that they seek to impose taxation on. And now, I think that the words including for schools of water very much modifies, or not modifies, but it confirms our interpretation of the ordinary meaning of local government services or improvements. They chose as examples of what local government services or improvements can include to be quintessential local government services. Now, I'm not suggesting because there's no school at the Mary River lands that they can't impose taxation. They don't need to provide schools or water, but they need to provide services like schools or water. That restricts the type of government activity that would justify a tax on Inuit lands. These are distinct from examples with much broader territorial application. And I'll go a step further because I heard my friend yesterday suggest, well, but the territorial government, we do fund local services because we do fund, the government in Clyde River, for instance, and they provide local services to their locality. We say that, the types of examples that they chose here are specific examples that denote government activities with a very close connection to a particular area. And here, the area we're concerned with is the Mary River Inuit lands, or in another example that may come up in the future, other remotely located lands where there is no hint of government services, where Inuit are on their own. We say there is the ordinary meaning here. Just based on an ordinary meaning, there must be a type of local government service restricted to a particular spatial area that's delivered. The point I made on Monday was that I think it's an affront to the plain and ordinary meaning of local government to suggest that the negotiators intended to provide a wide ambit to conduct the sort of wealth redistribution scheme that my friends from the government of Nunavut, for the government of Nunavut, indicated was plain on the face of this wording. It doesn't track. And I think if you had a time machine and said, well, let's replace all of these words and just indicate it's a wealth redistribution scheme, that Inuit-owned lands far removed from any of these population centers where government services are offered, those are liable for taxation. Those are liable for assessment for the purposes of taxation. And so, at risk of repeating myself a little too much, what I concluded that section with was the task here: give the ordinary meaning, and give that ordinary meaning to each word, and read the sentence together. To defer to the text, our submission is that a tax or other assessment to be imposed, it must be imposed for services or improvements provided in the vicinity of lands to be taxed, in a way where you can draw a connection between services or improvements and those Inuit-owned lands. Here on the record before you, it'll never be clearer than here. There is no connection between the local government services offered in Clyde River, in Pond Inlet, and Igloolik. Those are the closest places to these lands. There is nothing in this record that suggests a connection whatsoever between those local government services and these Inuit lands. So that was as far as I went on ordinary meaning the other day, Chair. Is there a specific item or question that I can help address?
That was exactly what I was hoping for. Is a lot of information this week, and I know this is a key part of your argument, so I wanted to make sure I was clear as to exactly what you were saying, and you've done that, so thank you.
Thank you.
I'm not hearing any other questions from panel members, so maybe we could move on to Baffinland's response to either this presentation and or the Government of Nunavut's presentation. So maybe we could start with you, Matthew.
Yes, thank you very much. Thank you very much, Mr. Chairman. I do have a reply to some of the comments that we heard yesterday from the Government of Nunavut. And I'll focus mainly on local government services and improvements aspect. And then my colleague, Ms. DeYoung, will follow up on some of the points relating to valuation of the specific items. And as a preliminary comment, I'd like to say that BIMC supports and adopts everything that you've heard this morning. In fact, throughout generally the submissions in support of our position. that the Mary River lands are not subject to either assessment or taxation, particularly the comments you heard this morning. And that'll help me shorten up a little bit about what I otherwise wanted to cover this morning. But I'd like to start just with, I'd like to sort of identify, my approach is going to be to identify some of the specific things that were said and that we heard yesterday from the government of Nunavut, and then share with you Baffinland's response. I'd like to start with one comment that my friend Ryan Baxter made. This was with respect to the tote road, and I will not be addressing the tote road, but in his comment about the tote road, he highlighted what the specific wording was in the right of public access. And he emphasized for the purpose of transportation. We all recall that, for the purpose of transportation. He says, if it's not for the purpose of transportation, it's not contemplated. He said it was very prescribed and very limited. As a matter of fact, he went so far as to say a dog sled race doesn't meet the definition or the right of public access, which is for transportation. Now, just as an aside, we don't agree with that, but the point that I'm addressing is he emphasized that's what the words are. The words are for a particular purpose, and the purpose is for transportation. And if you don't meet that particular purpose, you're outside the box. And from our perspective, it's quite interesting that he would highlight that, because we would say that that's a glaring inconsistency with respect to for the purpose of transportation when it suits them to read it narrowly, to read it down, where in the Nunavut lands claim agreement, it also has a purpose, imposed for, and I've gone on about this, imposed for local government services and improvements. There's a purpose there too. And that's our point, and that's a treaty right, and that's a quasi-constitutional document, and that's what we can. And they would pick and choose when they wish to emphasize the importance of words, and so that's the point I want to make specifically with that. The key language here, on the threshold issue, is the purpose for which these taxes may be assessed and levied as payable. So my friend Miss O'Neill also described the issue imposed for government services improvements as the threshold issue. We agree with that. If the government of Nunavut is wrong on its submissions, then QIA and Baffinland prevail in that the Mary River lands will not be subject to either assessment or tax payable. And then Ms. O'Neill got into the detail a little bit more, and she said, well, the appellants here, QIA and Baffinland, they're really parsing words and, in looking at the language. And I must say, that's a surprising submission coming from counsel or lawyers generally, because I would suggest that that's the very nature of the exercise we're engaged in. That's what the Supreme Court of Canada says you must do. And we've gone through how this panel and courts generally are to interpret contracts, treaties, etc. You start with ordinary meaning, but then you progress through in the context. You juxtapose words. You see whether words are redundant. Are words the same? Are words different? Different words mean different things. That is the nature of the exercise. You are called upon to parse words. Now it's a full range of analysis, but paying attention to the details, paying attention to the specific words used and not used, and where they're found and where they're not found is the heart of the interpretive exercise that this panel and all courts everywhere are called upon to do. And she also suggested we use a common sense definition of property tax, and she referred this panel to the definitions of property tax and real property tax from the dictionaries. And what we would say is that's not really so much the issue, like what is the definition of property tax? Because what we have is real property taxation as a defined term. you don't go to the dictionaries for real property taxation because the definition is contained in the Nunavut Land Claims Agreement. And again, that definition, which was not, reviewed by my friend, contains the keywords imposed for local government services and improvements such as schools and water. And that wasn't reviewed by her in her dictionary definitions. And those are the keywords, of course, that are found in the definition. And that's what we must go through. It also ignores, of course, the historical negotiations in the context here, and of course, that words have meaning. My friend, Ms. O'Neill, also acknowledges, of course, because this is undisputed, that any properties taxes that are assessed or raised from the Mary River property would go into the Consolidated Revenue Fund. Now, that's a territorial fund for territorial purposes. And she says, well, that's okay, because the territory provides funds to the various communities all over the territory, geographically unconnected to, remotely distant from Mary River lands. And she brought us to the territorial business plan. And this, this fact raises a number of problems for GN. Firstly, of course, it acknowledges that any local taxes raised out of the Mary River properties goes into the territorial fund. It goes in the consolidated fund. We see, like, right there, that should be a full stop or a full answer to the arguments of the government of Nunavut. It doesn't go in for local purposes. It goes into the territorial fund. And there's a complete disconnect with any physical, where these funds go, with any physical or financial connection with the assessed property. There's a complete disconnect. They would be taken from the Mary River lands, geographically located where we've seen in the maps, plopped into the Consolidated Revenue Fund account, which is presumably in a Iqaluit or some bank somewhere, and then redistributed, as my friend Mr. Langlois referred to, as a redistribution mechanism throughout the entire territory. It is beyond dispute that the local taxes are mixed into this big pot of money called consolidated funds. And we say there's significance to that because they lose their character. It's like scrambling an egg, right? You put in different eggs, a small egg, a medium egg, a large egg, a white egg, a brown egg, and then you make your omelet. And then from that, well, you give a little piece to some of the hamlets. The source of the funding, the amount of the funding, once mixed in, has lost its character. And you cannot say that this dollar from the Mary River lands is a dollar that goes to any local government service or improvement, firstly, because the Consolidated Revenue Fund goes for all purposes. It goes to pay the salaries of the politicians. Right? And we reviewed in some detail where all that money can go. So our money, the Baffinland money, if it's found that its properties are properly assessed and taxed, don't necessarily go to any local government service. They certainly don't go to any local government services in our area, because we know and everybody's acknowledged that there are none. But there's no guarantee that money goes to any local government service, be it in Cambridge Bay or Pond Inlet or anywhere else. It's lost its character. It's mixed. And this is well recognized, we would say, in the law. When you have mixed funds, they lose their nature. It's like a mixture of trust funds, that sort of thing. It is no longer local revenue. It is a territorial fund. And there's no guarantee that local taxes that BMIC would pay go to any local government services in any hamlet. It's impossible to unscramble the financial omelet once mixed together in the consolidated fund. Furthermore, once the money goes into the consolidated fund, as my friend acknowledged, even though she says, well, some goes to local government services in any hamlet, in any community throughout the territory. there are no restrictions. It is really left to the whim of the territorial government to decide which hamlet gets what, which hamlet gets how much, and whether it cuts it off at some point in time. It's all a matter of where the territory places that expenditure on the territorial ledger. It's clear in our submissions that, in hearing my friend, is that she acknowledges the monies for territorial purposes, although under the guise of a redistribution to the hamlets that she says includes some distribution for and payments for local government services in those hamlets. She ignores, of course, the provisions of PATA, under section 75 and 76 that we've looked at, that clearly distinguish territorial purposes and local purposes. The government of Nunavut says that there is no geographic connection or requirement imposed by the lands claim agreement when it says the taxes are to be imposed for local government services improved, can be spent anywhere. Well, we disagree. The entire legislative scheme, including the lands claim agreement, but PATA, the Cities and Towns and Villages Act, the Hamlets Act, clearly anticipate and provide that locally raised taxes are spent in the localities where they're taxed. The government of Nunavut says that the appellants have put a caveat on the definition of real property taxation. We haven't done that. The lands claim agreement has that caveat. The lands claim agreement, the treaty obligation, says must be imposed for local government services and improvement. My friend referred to the lease between Baffinland and the QIA, and says that the reference, there's a reference to property tax in the lease, and she said, well, it's not really to interpret treaties, but it shows that the parties anticipated that Baffinland would pay the tax. And we say simply that the fact this was referred to can't turn this into an admission that any sort of unlawful, if it should be found, or inapplicable tax, if it's found to be unpaid or not to be paid or shouldn't be charged, somehow obliges Baffinland or QIA to do something which the law doesn't require. And my friend also said, well, currently no property taxes are paid. Well, that's because this issue is in dispute. This issue, we're contesting it, and that's why this issue is before this panel. And this will get worked out one way or the other, and there'll be an obligation to pay or not to pay. So that's really irrelevant because it's a live issue that we've brought before this panel for an adjudication. My friend also referred to, Ms. O'Neill referred to, these outpost camps, and it's article 22.2.4, and it was turned up moments ago by my friend, Mr. Langlois. She says it'd be, and I think the words was, she said, I can't imagine that an outpost would be assessable or taxable. Can't imagine. Well, but for that provision in PATA, they would be. Excuse me, not PATA. Yeah, under PATA they would be, but for that provision in the lands claim agreement 22.2.4, they would be. So that's why it's in there. It is imaginable. PATA imagines that, and that's why we have these protections in the lands claim agreement. GN said that there's no particular requirement that a specific parcel assessed must draw on or have made available to it the local government services or improvements. This sort of ties in a little bit to this proximity argument that she would suggest. The argument is services must be provided to the parcel tax, and we've never quite said that. We've never quite said that. What we do say, though, is that there needs to be a real and substantial connection to the lands assessed and taxed and the government services and improvements provided. And we haven't gone into it in a lot of detail because the facts of this case are nowhere suggest that, right? We got into that a little bit, which my friend didn't review, was that Gander case from Newfoundland, where a rural property was brought into a larger municipal area, although outside of the town proper. And there's an argument, well, we're sort of next door, we don't get all the services, we get some services, that whole thing. we don't need to get into that here. If Pond Inlet were in the parcel immediately adjacent to the parcel of land on which the mine is located, and people would, go home for lunch and then come back and finish their shift and go home and then, come back the next morning for work and all of that stuff, that would be a different exercise, I assume. But we haven't really gone into that because it's not necessary. Those aren't the facts. So the facts aren't even close. So there's no suggestion or need or requirement that this tribunal must deal with about this proximity argument that only that the services must be provided to the lands assessed and taxed. The government of Nunavut as well referred to Article 22.1.1 of the Lands Claim Agreement, where the definition of personal property is defined just below real property tax, and drew a distinction between the two definitions. And I'd like to highlight for you, I'm not going to turn it up, but it's Article 22.1.1 of the Lands Claim Agreement, where personal property tax is defined, and it is having identified that. What the government didn't highlight for you is that in the definition of personal property, there is no local purpose imposed on any taxes raised on personal property. There's nothing there like we have immediately above in that same clause imposed for local government services or improvements. It just says personal property. And again, this, different words, different meaning, words that are used are intended to have meaning. All of that we reviewed with you. The government of Nunavut also said yesterday, if a municipality imposes a property tax, it can be assumed it's for local purposes. Quite right. The legislation requires that. Right? That's their mandate. That's what everybody would expect. But that's not the case for the territory. They purport to have the ability to assess and tax our lands, but it doesn't go for our local purposes in our geographic area. And this, as I say, there's no guarantee that those funds go for local purposes, government services anywhere in the territory, although they say they give them money for that as well. And this, by getting close towards the end, the government of Nunavut made repeated submissions about local essentially as the general taxation area and all the communities therein. And she said, if you can't tax Mary River lands, then the broader community will not benefit. And she said as well that the purpose of this tax is to distribute throughout the land base to benefit all. And my friend, Mr. Langlois, I thought was very effective in addressing this concern. But I'd like to add to it a little bit. And of course, we disagree with this fundamental approach and perspective of the government of Nunavut. And these taxes are not to be for broad territorial purposes, as she's acknowledged. Okay? I mean, it's interesting too that they seem to acknowledge that, well, for local government services improvements, they seem to acknowledge that that's an obligation they have, because why? So, well, that's what we do with it. Their argument is, well, that's where we're spending this money. As a matter of fact, we spend a lot more, right? So we're okay. We comply with that definition of real property taxation because that's what we do with it. Well, we disagree with that, but it's an interesting apparent acknowledgement that they say, well, we spend the money where it's supposed to go. But we say that this concept of benefit to all is this disconnect between the land where the taxes are raised and the services provided. The taxes are not imposed to benefit all. Rather, the taxes to be assessed and levied as payable are to benefit the Inuit. And there's no certainty that taxes provided to a distant hamlet have an Inuit population or majority Inuit population, or is there any test as to how it benefits the Inuit? Even if the money is, taken out of the fund, not having been specifically earmarked when it was raised, dispersed to a hamlet for local government services. There's no evidence of how that benefits the Inuit. It's assumed that it benefits the Inuit without there being any test analysis, or accountability. The GN, of course, did not address any historical and treaty negotiation context here, or how to interpret a treaty, which is significant, and we would say it's because presumably that analysis and review doesn't help. And finally, and it really distills down to this, GN says local has no geographic context, yet seems to acknowledge the purpose can be local government services, but local means fire and water, but doesn't mean in your area fire and water. And that probably is one of the key areas of dispute. We of course disagree with all that and urge upon this panel to come to the conclusion that the government of Nunavut has not properly met the requirement set out in the treaty that the taxes sought to be assessed and levied as payable are for local government services improvements, and ask that they reject the government of Nunavut's position. I'd like now to invite my colleague, Ms. DeYoung, to address some of the other points that address valuation of some of the equipment.
Thank you. So I'd like to, in reverse order, go through some of the points relating to the assessment or the valuation of the items in dispute. And I want to start off with the general areas and then talk about the portable crushers and ending with the tote road. So in respect of the general areas, Council for GN spent some time discussing how parcels are assessed under PATA. But the real question is whether that needs to be modified in view of the Nunavut Agreement. You heard Council to GN argue that demised means demised to Inuit, and said that the assessor is looking at what has been conveyed to Inuit. There are two issues with that interpretation. So the first is in respect of Article 22.2.3, and I'd ask if we could pull that up. I can either pull it up or the secretary could pull that up from the record if that's more convenient.
Olivier, do you want Janet to pull it up, or are you going to do that?
I can do it. I just got to pull it up here. So whoever's first can do it.
I have it ready, so I will share my screen. So looking at Article 22.2.3, this is the demise section. And what it says is that notwithstanding where an improvement has been constructed and an area of land for that improvement has not been demised, the assessor may assign an area no greater than 4 times the total ground area of the improvements. Now, the issue with GN's interpretation is that if their interpretation was correct, this phrase, this sentence would have no meaning, because by definition, Inuit-owned lands are lands that have been demised to Inuit. There would be no need for this section. The second problem with their interpretation is that it's clear that the demise being referred to is the demise for the improvement, because what it says is an area of land for that improvement has not been demised. So our position is that what needs to be looked at is what has been demised for that improvement. In respect of the portable crushers, You heard Councillor GN say during his submissions that integral means necessary. And I think that's an important acknowledgement. And you also heard him ask, why locate this expensive equipment there if it's not necessary? And the answer is, it's convenient. But convenient is not the same as integral. The fact that the crushers are being used, they're part of the operation, is not the same as being integral to part of the operation. Now, Mr. Towns in his affidavit does not supply any evidence that the crushers are integral. That's a conclusion, not evidence. There's no specifics provided about whether or not they're integral to other mines. And there's no evidence that they're fixed to the land. Now, if we look briefly at the transcript of Mr. Anderson, the question of whether the crushers or not are necessary is actually addressed in his testimony. And I'll share my screen again. Ms. O'Neill asked him, is the crushing part of the mining activity important? Answer, it's not important like it is at other operations where there's necessities to extract the metal from the waste material. It is important mainly just for our transportation. But we're not processing the material other than to make it easier to move down the road. Question, but you have to crush it to be able to transport it properly. We could use bigger trucks. And part of using the rail means we won't have to crush it as well. So coming back to this.
Excuse me, I think the wording was there, at all. We won't have to crush it at all. Can you pull that up again and just make sure that we have the right wording? I think it's, we don't have to crush it at all. As well. I'm sorry, we need bigger trucks. Using the means we'll have to crush it as well. I misspoke. You moved too quickly on me. The record, I stand corrected. Thank you.
He does go on to say, however, that they will not continue using these crushers after they switch to rail.
Right. I think I must have been thinking about another paragraph. Sorry.
But in any event, the key point here is that if GN, if we accept the submission from GN's counsel that integral means necessary, the crushers don't meet that test. They're useful, they're convenient, it makes transportation easier, but there are other solutions that they could use. So that's the crushers. So now I'd like to talk a little bit more about the tote road. And GN raised a number of important points in respect to the tote road, so I'd like to work through them one by one. So the first issue that GN raised was that they said there's no evidence that that right of access existed prior to vesting. We would argue that where there's a road on Crown lands, there is a public right of access. And we would argue that that is supported by the evidence in the QIA record, which addresses what use was being made of the road prior to vesting. And the reference is found at page 320 of the QIA record, and I'll pull them up on my screen again and share them with you. And this is the excerpt from the book written by one of the negotiators who discussed the process of negotiation from the Inuit perspective. And he talks about the tote road, the Mary River Road, in his recollection. And what he says is, in regard to the pond inlet selections, the outstanding item was the co-op airstrip on the Mary River Road, which serviced a sport fishing camp. One of those present was Joe Inuk, director of the co-op, and he addressed the issue effectively. Inuit had managed this business in the past and wanted to continue. The government contended that where the public wants access, as it does here, the government wants control. So this bit of old road with empty field drums along its sides due to no landing strip would be denied Inuit ownership. And we would submit that that's really important context to explain why this easement was specifically recorded in the Nunavut Agreement. It was specifically recorded to ensure that public access could continue as it had existed before. I would also note that the Territorial Lands Act, although it doesn't specifically reference the Tote Road, does in Section 23 talk about the right of the governing council to make an order for right-of-ways for a roadbed. But let's assume for the moment that GN is correct and there was no third-party right that existed at the time of vesting. Where does that leave us? We would say that in that case, Article 22.2.4 of the Nunavut Agreement would apply. And that's the article that says that certain improvements do not lead to Inuit-owned lands becoming accessible. And in item A, improvements that result from government or public activity do not result in Inuit-owned lands becoming subject to assessment or taxation. That still leaves the question, however, what does public mean? And you heard submissions from GN's council yesterday talking about the various policies Baffinland has created in regards to access and use of the lands. Fundamentally, however, there is a legal right of public access over the Tote Road. As noted by my colleague, Mr. Halpin, our position is that GN's definition is far, far too narrow. The easement is for the purpose of transportation, because that's what the purpose of roads are. Certainly, you couldn't use the road for a keg party, for example, but other types of activities that you would normally associate with roads are permitted. Going from one hunting location to another, we would say is transportation. I know Council to GN characterized a dog sledding race as a sport. However, I think it's very important to contextualize the use of dog sleds and the Nunavut Quest in the historical record. And in this respect, I think it's very important to have reference to the QIA report on the sled dog slaughter, which is found at QIA 474. And I will pull that up briefly. And I will share my screen, although this is maybe perhaps not one of the most central issues in this dispute. I think this is a really important report because it talks about the absolutely devastating effect which the sled dog slaughter had on Inuit. And essentially what the key findings of this report was that over a series of years, the slaughter of the sled dogs, or as they're known, Kmeet or Kinek, had an enormous impact on Inuit lifestyle. They didn't have a way to continue hunting activities. They were essentially confined to communities, whereas before they would have had a hunting lifestyle. And they talk about the findings here, and it's these are very important findings. But the outcome of this tremendous impact on Inuit lifestyle was something that the QIA found needed to be addressed and needed to be remedied as part of the process of decolonialization. And in the 2019 to 2020 annual report, QIA talks about what they've done to addressing these problems. And they talk about they hired a Kemeet revitalization coordinator whose focus was Kemeet related projects and programs. And what I think this emphasizes is that activities like the Nunavut Quest, where we see the dogs in their traditional fan harnesses, it's not just a sport. It is a form of transportation, and it is an activity that is specifically designed to revitalize this traditional form of transportation and lifestyle that was very nearly lost. You heard Council's QIA say that the road and the improvements constructed by Baffinland were not intended for the public. Again, we would disagree with that. And the reason we would disagree with that is that in constructing improvements to make the tote road more suited to its purposes and better able to be used for transporting loads, Baffinland cannot exclude the public from using the improvements on the tote roads. The broader public also gets the benefits of those improvements to the road. And yes, Baffinland is the primary user, but the fact remains that they are available to and are for the public just as much. Finally, I just wanted to briefly address the cases raised by Council to GN in discussing the approach to taxation and what the meaning of public is. So in Ballard, one of the cases cited by GN, it's important to note that there was no easement over the road in question. There was no right of access. And another important distinguishing factor, you'll recall that in Ballard, there was a flag person controlling access to the road. What we saw from Mr. Anderson's transcript of his testimony is that while there are mechanisms in place to report travelers, there's no way to enforce it. It's not as though there's someone at each end of the road who's assigned to monitor it 24 hours a day. In Ballard, the contractor had both legal and effective control over the sectioned off portion of the road. In the case of the tote road, Baffinland has neither legal control because there's a right of public access that's contained in the Nunavut agreement, and it doesn't have effective control because the road is simply too long and too large. And even if Baffinland had a practical way to limit access, it still couldn't do so because it would have no legal right to do so. Again, in the case of Fox, involving the Stoney Indian Reserve, we see, again, a very similar situation. There's, again, no public right of access or easement. The road in this case was on the band land, and there was no legal right of non-members of the band to use the road. The band had very clear legal authority to control access to the road, even though it permitted visitors. Baffinland does not. So those are the points in respect of the improvements that I'd like to make. To wrap up, what we say is that there is a very specific definition of real property taxation in the Nunavut agreement. That definition has to be given meaning. The fact that it uses a different word than the phrase used in PATA needs to be given meaning. And it's important to look to the history of the negotiations of the Nunavut agreement to understand the historical context and the tribunal should ask itself that when it looks at the agreement in principle, which is more logical, that having obtained a concession from the Crown that Inuit owned lands would be exempt from taxation, full stop, that Inuit then agreed to a narrow exception for real property taxation for local government services and improvements, including for schools and water. Or if having achieved that concession, they then walked back that achievement and agreed to the government of Nunavut's original bargaining position without any corresponding concession. And we would also emphasize that what Marshall in the case was following it say is that it is always important to look at the context, even when there's no evident ambiguity on the face of agreement. It is always important to look at the historical context when interpreting a treaty. And in this case, that's why we say that the evidentiary record that's found in the QIA's record is so important because it provides the context that is absolutely vital to understanding what was agreed to and why. So those are our comments in reply, and we are, of course, happy to answer any questions from the tribunal.
Okay, thank you, Jenna Ann and Matthew. I would now open it up to questions from panel members, and I'll start with Paula.
Thank you. I want to ask, I just want to check out if I am understanding something I think I understand in the agreed statement of facts. So that is, all parties have agreed no local services are provided to the Mary River mine. Is that correct?
Yes, we can pull it up, to make sure we have the exact wording, but that is, if not the exact words, certainly that's the effect of the language used in the agreed statement of fact. But one should be careful to follow the exact wording in the agreed statement of fact.
Can you pull it up for me, Mr. Halpin? Thank you.
I can't pull it up, but maybe
I can pull it up.
Yeah.
Okay, thank you.
Just give me 1 moment here.
Are you pulling up from the slide deck, Jenna Ann, or are you from the actual document itself?
I'm pulling it up from the record, and I will share my screen.
And this is agreed statement of fact. Which number is it? Is it 1 or 2?
Or you can just refer to the page number if that's easier.
Is this agreed statement of fact number 2? Go to the top.
I may be able to find it without that.
It'll be at the top of the agreement.
This is 1.
Okay.
So this is the section in the agreed statement of facts that deals with what the parties have agreed is not provided to the Mary River lands.
So we say that this section of the agreed statement of fact, which the parties have, worked up and have settled. So with respect to the wording here, we've agreed to all of this. So we've agreed, this includes GN, that there are no schools within 150 kilometers, no hospitals within 150 kilometers. The GN does not provide water distribution, sewer, drainage systems at Mary River. We've agreed as well, GN does not provide waste disposal. We've agreed, with GN. GN does not provide ambulatory emergency fires, etc. So we've agreed to all that. In addition, the record is supplemented by the affidavit of Mr. Anderson, where he goes into a little bit more detail. All of which is to say the effect of and the interpretation of the agreed statement of fact and the clear evidence to Mr. Anderson is that there are no services provided, local government services improvements provided to the Mary River lands, and I don't think that's an issue in dispute.
Okay, so can you advise that it covers all local services, including something like search and rescue?
Yes, 0 services, no services whatsoever, nothing.
Including search and rescue. Thank you.
Thank you, Paula. Rick, do you have any questions?
With regard to the crushers, I'm not sure I heard this correctly. Are they to be phased out at some point?
Yes, they are. And that's discussed in the affidavit of Mr. Anderson and also his cross-examination.
And I think on the crushers, on that very same slide at the bottom, he's asked the question, maybe Jen Ann, you can pull it up, where he says, the question is, once you go to the rail phase, are you still going to use these crushers? And I believe the answer was no. Jen Ann, can you pull up that slide? It's from our PowerPoint presentation.
I will pull up the transcript.
Yes, it's the transcript. Yeah, the excerpt from his examination. I think it's slide 149. 149.
So I have actually the original transcript up. So there's some discussion about this. There's a question he's asked, and you will intend to continue using these crushers after you switch to rail? And his answer is no.
Yes, that's what I'm thinking of. Thank you. So will you use these crushers, which now are sort of by the mine where the ore is? The rail, of course, will run to the inlet. You're going to use these crushers after you switch to rail? No, no. So, how important can they be? I mean, as my friend, or my colleague Jen Ann Young brought you through that, but they're not going to be used after they switch to rail is his evidence here.
Thanks very much.
Okay, thank you, Rick. I believe Paula has a follow-up question. Paula?
Yes, I want to, who provides search and rescue at the site? Is it provided at all?
Yes. So Baffinland has a mine rescue team. They provide all of those services. They're financed by Baffinland. If someone needs medevac, what happens is the territory bills back the cost to Baffinland, and that's actually recognized in the MOU between Baffinland and the Department of Health.
So there's no territorial responsibility for search and rescue at the Mary River site. Is that
That's
a correct understanding?
That is.
Okay. Okay, thank you.
Thanks, Paula. Jen, Ann, or Matthew, I have a couple of questions. So with regard to the crushers, and I'm wondering what their purpose was originally on site. Were they there because they were producing aggregate for the road? And because they're there now, they're simply being used by convenience to crush the ore? Or were they brought in for a specific reason? Thank you.
So my understanding, and I'd have to double check the record, but my understanding is that you're quite correct. They were originally brought in to crush aggregate when the site was being set up. And then since they were there, they've continued being used to make the aggregate smaller so that can be done at site before bringing it to the locations from which it'll be shipped to purchasers. But that was the original purpose for which they were brought to the site.
Okay, thank you. And I'm going to ask this question to you, and if any of the other parties want to respond. And out of curiosity, I'm wondering why there's been no discussion of the port itself. And is that because it's not contested? It's on federal land. I'm wondering why the port is not part of this whole issue.
You're correct. It's simply not contested. I would have to double check the reason for that, but I believe it may be on Crown land. But you're quite correct. It's not contested.
Okay, thank you. When the GN has an opportunity to respond, I'm going to be asking Ryan Baxter about this particular issue, and I'll ask it to you as well. But yesterday, in the government and Nunavut's submission, they talked about parcels P17, 16, and 19 being combined together because of the commonality of the tote road. So in your view, Jenna, and in your expertise, if the tote road was to be ruled that it was not accessible or taxable, what does that do to that argument of the parcels being combined together?
So I think there's sort of two parts to this. First, you have a road that's linking parcels that are not actually contiguous. And then in fact, there's that small strip of Crown-owned land in between them. We would say that they should not all be treated as one parcel. Now, we acknowledge that there is a basis for doing that under PATA, but we say that doing so ignores this key language in the Nunavut agreement about what you assess on Inuit-owned lands when there's an improvement. You assess an area that's 4 times the size of the improvement if there's no area specifically demised for the improvement. And if there's an area demised for the improvement, then you assess that. So in terms of, I think you're quite right to identify this issue with the road linking the parcels as being problematic if there's a conclusion that the tote road is itself not accessible. But the bigger issue with this approach is that it doesn't take into account the language of the Nunavut agreement, which makes no reference to parcels when it comes to assessing Inuit-owned lands with improvements on them.
And just to underscore the point, of course, it's quite evident in the map that we've looked at. I think it's QIA 1330 that shows the parcels, that section of Crown land in the middle. So it breaks or interrupts the contiguous flow of the road. So there's a disconnect between the parcels blocked by that Crown land. And as well, I think it's my understanding, and maybe my colleague, Ms. DeYoung, or the government of Nunavut lawyers correct me, they've said that the tote road itself is not an improvement, if I recall, and it is not assessed as an improvement. It's the bridges and structures and abutments, that sort of thing. And so the definition requires that where an improvement runs over several parcels of land, well, the tote road doesn't meet that definition.
Okay, thank you for that. I think that's all the questions I have. And don't worry, Ryan, I will be back to you on this, okay? So don't feel like you won't get your 2 cents in. So I think what I'd like to do is take a break now. And if Matthew and Jenna are done, we'll take a break now and we can come back and give the opportunity for the government of Nunavut to respond. So a 10-minute break. So I have 1/4 past, so 25 after. Okay.
Thank you, Mr. Chair.
Oh, okay. Okay, I think we're ready to continue. So I was going to, just want to clarify, I'm going to ask the Governor of Nunavut to respond to some of the things that have been said, and then I'm going to turn it over to everybody to respond as I'll coordinate it, but I want everyone to feel that any questions or any further points that you want to get across or any questions that we have of you, you'll have an opportunity to bring those forward. So having said that, Jane, I'll let you respond to some of the discussion this morning.
Actually, since we ended on the technical issues, Mr. Baxter's got a couple of points to make with respect to those, and then I'll follow.
Okay, great. Ryan, go ahead.
Thank you, Mr. Chair. Thank you, Ms. O'Neill. I just want to start by also acknowledging and thanking Mr. Lambrecht for making that statement on the record this morning. I think it was helpful for all parties to hear that. So that's just the first note. The second note that I would like to address was a question that Mr. Lambrecht had put to the GN yesterday with respect to the public use deduction. As you may recall, when I was speaking about the Tote Road yesterday, I mentioned that the assessor had applied a 50% reduction on what was being assessed on the Tote Road to reflect the limited public use that is made of the Tote Road. And your legal counsel had asked what the authority for making that deduction is. So I'd like to speak to that very briefly now. So to be clear, there is no express authority either under PADA or its regulations to deal with it. How it came about, when completing the assessment function, prior to even getting to the regulations, for each year, the assessor, so GN's assessor and BIMC's Altus representatives, they're going through the FAR and they're reviewing each line item in the FAR to determine whether the full expenditure is going to be reported and included in the assessment, as there are many items that are reported that are deemed fully 100% accessible, partially accessible, or 100% non-accessible. So in this regard, with respect to the Tote Road, it's the two parties that came together and had agreement on all the FAR line items, other than, of course, the items related to the Tote Road and the crushers. When the GN and the GN assessor and BIMC were talking about the Tote Road, BIMC indicated, it's my understanding that they indicated that anything associated with the Tote Road, there is a benefit to the public here. So that's been acknowledged, and it's the assessors with that acknowledgement thought it was appropriate to recognize that the public may benefit from those expenditures as well. So no mathematical determination of what portion of the reported costs were for the benefit of the public who use the road versus BIMC, but it was an agreement, is my understanding, between the parties that all FAR items with respect to the Tote Road were reduced by 50%. So I hope that answers legal counsel's question on that point. Now I would like to very briefly, this is not a recitation of any of my presentation yesterday, of course, but very briefly just to respond to a few points. And I know, Mr. Chair, you had a specific comment about how the assessor is treating the parcels as one. So I would like to respond to that as well. And maybe I will start with the crushers, however, if that's all right. So we heard from BIMC's legal counsel that the crushers are not necessary. They're not integral. They're there and they're being used, but they're not necessary for the operation. From the assessor's viewpoint, that's not entirely credible. And I say that with respect to Mr. Halpin's comments yesterday that if and when a railroad is constructed, that the crushers will no longer be needed. So if and when a railroad comes in, the crushers will no longer be needed. I think the tribunal can infer from that comment that the crushers are needed today. I think, clearly, if there comes a point in time in the future where the railroad is constructed, then they may no longer be necessary. They may no longer be needed. Certainly, if that's the case, they would also no longer be assessed. But in the manner in which they are being used today, the assessor does take the position that they are necessary, that they are being used. There was some discussion earlier today about whether or not the crushers are in place because they were used for the aggregate on the tote road. Well, certainly that is true with respect to some of the crushers. It's my understanding that even upon the completion of the tote road, additional crushers were brought to the area. So I think it's fair to indicate that there was a need, even additional, to the construction of the tote road for the crushers, and that's why additional crushers were brought in. There was comment about Mr. Town's conclusions in his affidavit, where he takes the view that crushers are integral to this operation, that crushers are integral to all mining operations in Nunavut, and that crushers in all mining operations in Nunavut are accessible. That was not contested, it was not challenged. BIMC had the right to cross-examine Mr. Towns on his affidavit evidence that he presented. It never was challenged. It was left to stand as it is. So those opinions and conclusions of the assessor are in the record, and they have not been contested through cross-examination. With respect to the easement, I know we've had conversation going back and forth, looking at the language of the easement, where it says the purpose of the easement is for transportation, and some discussion about whether the dog sled races would be considered transportation or not. The GN is not taking a hard line on that either way. And if there is being use that is being made by members of the public for transportation, that's fine. It doesn't take away from the fact of the very significant restrictions and controls that BIMC has published in its policies. So yes, there may be use of the tote road, very limited use, I would suggest, from the record, extremely limited use from the record of the tote road for a public purpose, which may or may not include transportation. That doesn't take away from the fact of BIMC's intent to monitor, restrict, prohibit even, as you will recall, some of the policies that we looked at yesterday have a prohibition with respect to traveling along the tote road. So yeah, even if there are circumstances in which the public uses it for transportation, it doesn't take away from BIMC's intent, which is encapsulated in those various policies. I'm going to share my screen at this point, Mr. Chair, just to be responsive to your question earlier about the tote road and what role it plays in connecting those three parcels. And if the tribunal reaches the conclusion that the tote road is not accessible, does that break the link? I think that was the nature of your question. So let me just share my screen here. hopefully I've gotten better at this than I was yesterday. And I have to go to display settings and swap percent. Are you able to see this definition here now in front of you? Okay, great, thank you. I don't think I'm on the right definition in any event. No, I'm not. Excuse me, just give me one correct definition. Okay, I got it now. So let me share my screen. So this is the definition in PATA that directs the assessor with treating those three parcels as one. So as I noted yesterday, parcel is defined and it says if an improvement that is affixed to land would, without special mention, be conveyed by sale of the land and the improvement is located on 2 or more blocks or tracts, that is what constitutes a parcel. So it's on this basis that the assessor is treating the three parcels as one. The commonality, as I mentioned yesterday, is the tote road. And Mr. Chair, I think your question was, well, what if the panel determines that the tote road is not accessible? Would that break the link between the three parties? From the GN's position, no, it need not be accessible in order for this definition to apply. What the criteria is whether or not there's an improvement. It doesn't go on to say an improvement that is accessible. It merely says an improvement. And I think it's clear, and the record will show that there is significant improvements that have been made to the tote road throughout. So I think if the tribunal says, you know, the tote road itself is not accessible, it's beyond dispute that it is an improvement, and that improvement does run across all three parcels, and that's the basis for which the assessor treats it as one parcel. Does that respond to your question, Mr. Chair?
Yeah, it does. Thank you.
Okay, no, I think it's a good one. I'm going to start my screen share again here and just see if there's any final points that I wanted to discuss. Just give me a moment. No, I think that's all from my perspective. Perhaps now I can turn it over to Ms. O'Neill, unless, Mr. Chair, you or your panel members have any questions on those points.
I think we can hold them until Ms. O'Neill's done, and then we can, yeah, sure. Go ahead, Jane.
Yes, I just have a couple of comments, one of which arose partly out of a question that Ms. Madden had, and that was related to the wording of real property taxation and a question relating to, well, couldn't it have been expressed more clearly? I think that was a question. There are questions certainly from someone on the panel, and the comments we have on that is that if the interpretation put forward by the appellants were to be accepted, we really think that that would have been spelled out clearly in the definition of real property taxation. If it was meant to be simply for local services used or services delivered by a local government, then it would have said so, or it would have set up a fee for service. In the current case, we do have BIMC who happens to provide search and rescue, fire, water, sewer, all things to the site. But this document is not just meant to cover the current situation, but the treaty is meant to live and go forward. So say, for example, there's an improvement on another parcel by a third party, for example, who provides water but nothing else, then are we back before a tribunal to determine, well, is that enough local service that they're using in order to fall within the taxation scheme? Is it not enough? And our view of it is that, again, just to reiterate, that local government services means exactly what it says. And this tax is imposed, as all real property taxation is, for local government services. One other issue I wanted to address, and I will haul out my screen for this. Let's see. So can you see Article 22? Oh, not yet.
We can
Can you
now.
see? Okay.
Yes. Yeah.
And this is directly related to 22.2.3. And frankly, I hadn't realized that this section would sort of play as much of a role as it has in the hearing. And I know we've all been struggling with what it means. And we've been focusing on the word demise. And so I've gone over it. And suddenly I came up with what I think is the most reasonable and simple explanation for why the negotiating parties included this provision and included it in this way. And by doing so, as with any statutory interpretation, I'm looking at the entire Article 22 in the context of what it is meant to do. So as you know, the position of the GN is that the starting point is that Inuit-owned lands are not subject to any type of tax at all. However, there are two exceptions. One when there are improvements within a municipality and when there are improvements outside of a municipality, leaving aside the definition of real property taxation for a moment. So looking at 22.2.3, there are two scenarios. There's the scenario like the one we have here, where an improvement is made on leased lands, or in our case, demise lands leased to BIMC. So the improvement there is the improvement, in essence, of a third party. The second scenario would be where QIA itself puts an improvement on Inuit-owned lands. And in our submission, the only logical reading of this provision and of the and within the purpose for which it's there is that it's to protect and cover off Inuit-owned lands with improvements. So stay with me here. So it says, if there are improvements on Inuit-owned lands, they shall be taxed as others. But the caveat here is, notwithstanding, where an improvement has been constructed and an area of land for that improvement has not been demised, the way I read that is where an improvement has been constructed on lands in which the interest continues to be held by QIA. So it's QIA who's putting an improvement on that part of the land. The assessor may assign an area no greater than 4 times the total ground area of the improvements. As an example, you've got a parcel of Inuit-owned lands. QIA, for whatever reason, constructs a building on that parcel. There's no third party involved. The lands have in no way been demised. That entire parcel of land is not going to be assessed. Only 4 times the size of the building footprint. And that is a benefit when it is being done by QIA as opposed to a third party. To illustrate again, my friend yesterday said, well, what if one building was put on 1 million hectares? Well, it's hard to imagine one parcel being 1 million hectares, but in any event, if QIA put one building on 1 million hectares, 22.2.3 ensures that QIA will be assessed for property tax purposes only on the area that's 4 times greater than the building footprint. And as I was going over this and going over this and going over this, as with any treaty or statute, words are not used just to be used, and provisions are not inserted just to be inserted. It has to mean something. What is this intending to do? What did the parties mean by putting this in here? And the common sense logical conclusion that we've come to is that it fits in with the scheme as we propose. Lands will not be taxed. When there is an improvement on the land, then it will be taxed. If that improvement is by QIA, the entire parcel of land won't be taxed, only 4 times greater than the size of the actual improvement. Now, for third parties that are lessees, like BAIMC in this case, yes, the entire parcel is assessed. But this is a further trade-off and further protection for QIA if they themselves are putting an improvement on the land. It's not to say it's not going to be taxed, because we know it will be under the first section of 22.2.3. But the entire parcel will not be taxed. And in our view, not only does that fit within the scheme, it supports the GN's submission on how the scheme was meant to operate, how Article 22 was meant to operate. And again, basis there is no tax, exception, improvements, exceptions to the exceptions, and that's That's the scheme, that's the trade-off, that was the agreement. And just one thing we didn't touch on that I thought I might want to, just for the benefit of the tribunal, is that we talked a bit about how these property taxes could be collected should they be unpaid. And that's addressed in 22.2.5. And you'll see that under this scheme, Inuit-owned lands are always protected, no matter what, even if they're in arrears in property tax. It says that there can never be a charge, pledge, attachment, seizure, execution on those lands to cover property taxes or arrears. Now, personal property can be used to cover arrears, but the lands will always remain intact and cannot be subject to seizure for the failure to pay property taxes. And subject to questions, those are the submissions arising out of the questioning from the panel.
Okay, thank you very much, Jane and Ryan. Open up for questions from the panel members. Paula? You're muted there, Paula. There.
Okay, I'm not sure. I have a question on what you just said, but there was a question that you had earlier about a question that I asked. You wondered whether it was a question or not. And I'll need some time to find that now. I wasn't expecting to reply to that now. Sorry, I'll have to come back to that because I will have to find it. I think that it was a question that was related to GN's taxing, GN tax and the use of that to provide services. I'll have to come back to that.
Okay, we'll have an opportunity to ask. Go ahead, Rick.
Question on the mill rate. You had a slide on it yesterday there, and we talked about land earmarked for exploration by BMIC. And there are no improvements on that land, and yet it was subject to tax. And you explained what that was about and whatnot. I'd just like to find more about how mill rates are determined. Maybe in terms of the land we're looking at here and the property.
So I'm wondering if you're referencing Mr. Armstrong, the development quotants that I was discussing for raw land yesterday.
Yes.
Okay, certainly. Let me just share my slide here. Jane, can you stop sharing? I can't share while you're sharing. Too much sharing. Okay, I think you can see the screen here now, can you? Yes, okay. So in the regulations, this is from the regulations for the general taxation area. So the regulations themselves assign a number of quotants for raw land, road development, parcel development, surveyed land. And the region that we're working in right now on Baffin Island is the Kikatalik. So the regulations specifically direct the assessor to assign a value of 7 for any raw land that has no development on it in the general taxation area. So that is why the assessor is including that value in their calculations of the assessment of the land. It's directed specifically in the regulations of PATA.
Okay, for the section there marked parcel development, this one might have to do with improvements, say on the road, crusher and whatnot. Does that fall into that section?
So it would be for more developed areas of the parcel. That's correct.
Okay. And so you have a value there, for example, in the Kikatalik area, somewhere between 0 and 24. And what goes into choosing a value there?
So I think it's the degree of development. So obviously the impact and exploration areas would be assigned a higher value. So it really depends on the degree of the improvements that have been made to the land.
Okay. So what you'd be doing is adding up the various numbers there, putting them over 1,000 and coming up with a value that can be used as a mill rate, and multiply the assessment would be applied against that.
It may be helpful for me to bring up the actual calculation. So that is included in Mr. Town's affidavit. If you give me a moment, I can bring that up and show you where it's used in calculating the assessment value. So just give me a moment to bring that up. I will say it's probably going to take me a minute or two to bring it up though, Mr. Armstrong. So if you have questions in the meantime, happy to take.
Yeah, I wonder if I could direct one to Jane. Jane, I was wondering, can monies received by the GN for taxes not be directed or earmarked towards a particular use? For example, I'm thinking taxes received for beer wine sales, I believe, are directed into territorial health department, or gas tax is directed towards road improvements. Could you speak to that? I guess we've always considered that everything goes into general revenue, and I don't know whether that's a fact or not.
I don't know the answer to whether there's something in the Financial Administration Act that directs real property taxes to go to local government services or not. I do not know the answer to that. I will check, but I do know the reality here is that we know that any dollar collected is going at least in some way to local government services, as there is a tenfold shortfall in budget to revenue for local government services. So I'd have to check the statute to see if, and I'm just not aware if there is anything directing property taxes as collected.
Thanks, Jane. We're still waiting on Ryan. Oh, sorry, you're muted there, Ryan.
Yeah, I'm still bringing that up. I'm sorry for the delay, but I will get it here in a moment, Mr. Armstrong.
Okay. Anything else, Rick, while you're waiting for that?
No, that covers it as far as I'm concerned. We just have the question Ryan is looking into.
Okay.
Okay, so I have it here now. I'll share my screen. So this is at Exhibit R of Mr. Town's affidavit, where he goes through the very detailed calculation for the assessment of the parcels and the subject property. So he, in the regulations, it's very described. The inputs are very described, but that number 7 comes in at both 3 sub 5 sub B as well as 3 sub 5 sub E. You'll see in both places there's an indication of a raw land score of 7. 12 for the survey, 0 for the road, 24 for the parcel development, which is 43 out of 100. So that becomes part of the calculation in both B and again in E. So that's probably as detailed as I can provide an explanation of it on the GN's behalf. I'm not an expert in these calculations by any means, but that is where that number 7 is found in the calculations.
Thanks very much.
Certainly.
Okay, thank you very much, Ryan and Jane. I don't have any questions. Paula, did you want to go back to your question?
Yes, I do want to go back to my question, but I think that Ms. O'Neill was not clear, and I think Mr. Halpin was also not clear that I was asking a question when in fact I was asking a question. And my question was about taxation. So it was, is it not fair to say that Inuit would also benefit through improved and increased programs and services provided by the GN through an increasing tax base? So that was the question that I think that a couple of the counsel for the parties weren't clear about.
Okay, is that directed towards both Jane and Matthew, or?
Yes, yes, it is actually. So my reply is yes, I did ask a question, and this is the question that I asked.
Okay, why don't we let Jane tackle first and then Matthew second?
Yeah, I'm not sure if Jeff was part of that too. But yeah, okay.
I'm sorry. Can you just let me know what the question is clearly again? I want to make sure that I answer it as directly as I can.
Sorry, you're muted. Oh, sorry, Paula, you're muted. You have to start over.
It's the kind of day I'm having, sorry. Okay, so is it not fair to say that Inuit would benefit through improved or increased programs and services provided by the GN through an increasing tax base? Right, so is it clear now?
It is, and
Okay.
thank you for that question. And the short answer is yes. And it's in the GN submission that's exactly how Article 22 is to be read within the scheme of property taxation and economic activity in this area. That, lands themselves won't be taxed. However, if there are improvements, those will be for the benefit of providing local government services in the general taxation area. And again, as I said just earlier, that when it's a third party doing it, the entire parcel is taxed. When it's an improvement to land by QIA, then it's restricted in what can be taxed. But yes, economic activity in this area is to expand. Surely that's not the only purpose, obviously, but one obvious benefit is to all Inuit by expanding the tax base.
Okay, thank you, Jane. I'm sure Matthew might have a comment on this and maybe Jeff as well. So I'll start with Matthew.
Sure. And thank you for that question. It's an interesting question, but it's a very broad question, and I'll answer it in part by saying I don't think it's the specific question before this panel. The question before this panel are these properties, which are the subject matter of the appeals for the years in question, are they accessible and is tax payable? That's the question before you. It's a much broader question to say, well, you know, isn't it a good thing that taxes are raised and imposed because we all as a society benefit from taxes being imposed, and then assuming that the taxes then are spent in a manner which is positive, productive, you know, and not, you know, and beneficial. So there are a number of assumptions there, but my initial answer is it's not the specific question within the mandate of this panel to resolve. To answer it though as best I can, it is a very broad question. Say the Inuit, well, which Inuit? Like the Inuit in the area of the Mary River lands, or the Inuit up, you know, way off in the western part of the territory? And we're talking about which people will benefit, you know, and so we say that there must be a connection. So who benefits? And if it's so broad like that, is the benefit limited to the Inuit, or is it all residents of Nunavut? Right? If the monies are spent, you know, on improvements to the airport in Iqaluit, is that something that is contemplated by local property taxes raised way up on Baffin Island? You know, so it's who and where. And the other thing is what services, right? I appreciate that Nunavut is not a independent country, but taxes are raised sometimes at a federal level, a state level, at the country level for national defense, you know, armaments, things like that. That's obviously not applicable to a territory or a province within Canada. But the question is so broad is, well, where are these monies being spent and who's benefiting from it? So I appreciate the concern, and the premise is, you know, by raising taxes, we give the government the tools to do what's necessary for the good of the larger people. That is more of a philosophical and academic question than one probably within the purview of this panel. So that's what I would have to say to that. Thank you.
Okay, Paul, I'm going to move over to Jeff for a comment. Go ahead, Jeff.
Thanks, Ms. Madden, for the question. I'd echo some of what my friend Mr. Halpin just said. I think the premise of the question is a little bit overbroad, and I think, you know, I'd ask you to hesitate before equating the increase in Government of Nunavut revenues with Inuit benefit. Certainly, there are government services that are provided and benefits to the Inuit and non-Inuit population alike. Of course, like, I just want to take a step back here about what's being imposed here. What's being imposed then is assessment on Inuit lands delivered to Inuit organizations, here QIA. It's QIA that is being asked to pay those taxes, albeit, as you've seen in the lease, we have an ability to ask our tenant to do so in this circumstance. But I ask you to remember, the interpretation that we're making today is going to apply whether we have a tenant or not. If, as Ms. O'Neill suggested, maybe there'll be some improvements that are developed by Inuit on their own lands, at their own expense, far and removed from any government services. In that case, if Government of Nunavut's interpretation is accepted, those would be taxes payable by Inuit to the Government of Nunavut. That, to me, I don't see the direct benefit in that circumstance. QIA's mandate is to provide representation and benefits to its community. And I just refer you to paragraphs 23 and 28 of our written submissions. In those paragraphs, we list some of what QIA does, including direct service provision, including daycare, educational resources in 55 communities across Nunavut. We also, in Appendix C to our submissions, set out a little bit more about what the Inuit organizations do. So there's actually direct contributions to Inuit well-being and services that are provided by QIA, who of course here would be the taxpayer for Inuit lands. The only other point I'd offer there is, again, this is not necessarily about the parties at this point or the tribunal in answering this question. It's not about designing, well, what's the best taxation system? It's about determining what was the taxation regime that was decided upon in the treaty. I heard, we're giving you a difficult task. You're hearing from all council here saying, it's totally clear what these words mean. And of course, we're offering you a different interpretation of those words. But I think it is clear that the taxation regime does require the imposition of a tax only where there is local government services and improvements. That's just literally the words that are used in that provision. And just you're, I think, looking for a rationale as to, well, how does this benefit Inuit to not pay tax? Wouldn't it be better to do some of that wealth redistribution? I agree with you, and that is frankly what will be going on many Inuit-owned lands. Inuit-owned lands adjacent to communities where there are improvements made on those Inuit-owned lands, or where there could be improvements made on those Inuit-owned lands, are available for property taxation and are taxed under Article 22. Those can be used to distribute some of the local wealth to local government services that are provided. But there are competing uses for Inuit-owned land under the agreement. One of the core purposes of Inuit-owned lands that I brought you to in our submission was for the purpose of Inuit pursuing economic activities on their own land base. It's a land base they fought for and won in this agreement. And we say one of the rights that came along with that was a different taxation regime. And there were choices and compromises made, and the parties fundamentally decided this is how we start to reconcile Inuit rights and title with the Crown's assertion of its own sovereignty and ability to make decisions in this area. So the question you ask, I think is a good one to have in mind, but there are many different facets as to what would benefit Inuit. And I'd hesitate, or I'd ask you to hesitate before determining that GN revenue equals Inuit benefit, because of course, in this circumstance, it may well come from Inuit directly. So thank you for the opportunity.
I just want to reply to that. So I'm not rationalizing or concluding. Simply my question is to elicit some further responses from council on the question that I asked. And so on an issue that came out of your presentations, just to clarify. Thank you.
Thank you, Paula. Thank you, Jeff, Matthew, Jane, and Ryan. I'm going to suggest we take a lunch break, and when we come back, provide an opportunity for final comments and questions, and then we can deal with the matter on jurisdiction, and then I think we'll be done business for the day. So if everyone's okay with that, we'll take a break, come back at 1/4 the hour. Thank you.
Thank you, Mr. Chair.
Thank you.
Trolley. Wipe my face off, trolley, trolley, trolley. Brush us with her teeth. Trolley, trolley, trolley. Eat us these fine. Trolley.
There are some things you just don't do halfway. Fighting COVID-19 is one of them. As vaccines roll out, let's keep giving this our all.
Just wondering if Jane and Ryan are on in area.
I'm here. Thank you.
Hi, Aria.
Hi.
Oh, Ryan's back. Jane's back. Okay.
Sorry,
Welcome back.
Ryan and I were gabbing.
Oh, that's okay. That's okay. Welcome back for the final push here. So what I was hoping to do this afternoon is to open it up to final comments or questions from anybody. And once people are satisfied that they've got they're done, we'll speak to the issue on jurisdiction, and then we'll have some concluding remarks, and we'll go from there. So if everybody's okay with that, I'd like now to open it up to final comments or questions. And if you kind of raise your hand, I'll coordinate through the chair. Okay, I see Jenna Ann up first. So Jenna Ann, you go ahead.
Yes, so a few days ago, I guess would be, today is Thursday, so it would have been Tuesday, counsel to the tribunal had asked if there was a map in the record showing the impact area and the exploration areas. And there is in fact a series of maps in the record showing this. They are schedules to the commercial lease, and they're found in the record at BIMC 142 to 146. However, you need to read them in conjunction with the explanatory description of the maps that's in the lease at BIMC 73 and BIMC 74, because some of the terms that are in the lease, for example, impact area versus high impact areas, don't exactly track with what's on the maps. You need to be able to read what's in the lease alongside with what's on the map to see what the map is actually saying in relation to the categories as they were finally reflected in the lease, if that makes sense.
Thank you for that, Jenna Ann. Anybody else have final comments or questions they'd like to raise? Go ahead, Jeff.
Just final, and I think it's a small point. There's been some discussion this morning about how the taxation revenue that the GN collects in the general taxation area, how it must be necessarily seen to be used for local government services because those funds don't exceed the funds that GN has indicated that they spend on local government services. The only point I want to reiterate there is that that spending that my friend Miss O'Neill has discussed is only local in the sense that GN defines local, which is to say spending that occurs throughout the general taxation area. Here, I suggest the only number that matters to you is that there is, for these properties under issue, for the years under appeal, based on the assessments that are before you, the notices of tax payable approximate somewhere between $2 and $3 million, depending on the year and the assessed value. So that's the tax on one hand. That's the amount of tax imposed for local government services. On the other hand, we know the spending that is occurring on local government services in relation to these Inuit-owned lands. We know that number is 0. I suggest that's the only number that this panel needs to be concerned about. GN's finances in the future may well change, but our point is if you are accepting of our interpretation that local actually means local, you need not be concerned about whether or not they make up, they fund other services elsewhere.
Okay. Thank you very much, Jeff. And I'm looking for any further comments or questions from any of the other parties. Not hearing any. Then I would like to move to the issue of jurisdiction. We added that to the record yesterday, and I wondered if any of the parties have any comments on that.
I just had a question on sort of the procedure of it. Was the tribunal expecting that the parties would all file at the same time, which I would call, cross-filing, or whether appellants would start, respondents would reply, there'd be a back and forth, or just a one-time filing by all?
If before, Mr. Chairman, you rule on that, we haven't had a chance to discuss this proposal, the procedural proposal for further submissions as amongst the various parties, council. So we're approaching it a bit cold now. I would say this, we're, as you heard from all council, we were all a little bit surprised and hadn't by this issue and hadn't obviously addressed it in our written material. So at this point, we don't know. We speaking on behalf of BAFLAN, I assume that's the same for my friends at QIA, don't know what the position of the government of Nunavut is. It may be that we're all on the same page, in which case, at least from the submissions you'll hear from council, I would expect a fair bit of harmony. But if there's a divergence, because it's not an issue that we've explored really amongst ourselves, my suggestion would be that the appellants go first and that we make our submissions. Then the government of Nunavut would have a chance to review that. If they agree or complement that, but basically, we're all on the same side, that's an easy task for them. But should there be a divergence in views on what the jurisdiction of your panel is, then we'll hear that for the first time from the government of Nunavut, and then we would have a corresponding right to reply. As I say, we may all be on the same page, but because it's uncharted territory right now as amongst ourselves, I would suggest that may be a more appropriate way to go.
And just on behalf of the government of Nunavut, again, must say that we have not had the opportunity to look at the issue in depth. So I can't say right now what the position is. It may be that after council confer, we may all be on exactly the same page. I just don't know.
Okay, with your indulgence, I'd like to move to a breakout room with the tribunal members and our legal counsel, and just give us a few minutes to discuss, and I'll get right back.
Chair, I don't know if it's...
Sorry, go ahead, Jeff.
I just say, I don't know if it's possible technically, but I wonder whether it might make sense for all of the rest of council to be put into a breakout room, and we could, assuming you come back with a proposal about order, we might be able to be all on the same page in terms of timelines.
I think the easiest way to go, Jeff, for that would be if the panel were to go to a breakout room and just leave us behind. We're already in.
Fair enough. Yeah, sorry, I'm making it more complicated.
Subject to any technical challenges that Bruno may have.
But my question on that, though, is because we had asked that the main proceeding be recorded, I want to ensure that council's discussions behind closed doors are not being recorded.
Good point.
So Bruno, can they be moved? Can the rest of the members be also moved to a room?
Yes, I can definitely move them to a separate room. You can still stay in this room. What I'll do is just I will stop broadcasting that part to the YouTube. So your choice. I can easily move you all together to a room.
So what we would like to
recording.
Yeah,
Sorry, say that the recording. Yeah, I'll stop the recording for that too.
Yeah. So what we would like, Bruno, is to move to two separate rooms, and so the regular panel members and our legal counsel in one, and the rest of the members in another.
Not a problem. The panel's room is already ready to go. I will move everybody else into a separate room altogether, and then I will stay in the main room.
Okay, thank you.
Thanks, Bruno.
Oh, sorry. Oops. Sorry, I need to go back to the, Bruno, can you get me back to the breakout room? I don't know how I got back
Click
there.
on more. There's a button that says join breakout room.
Oh, I can't see it. Oh dear.
The three dots on the bottom, there should be an option, join
Leave?
breakout room.
I'm just not seeing it. Just one moment. Okay. I'm gonna need some help. I just
Bear with
believe.
me. I will do that for you right now.
Thank
I'm
you.
just checking if just a second, okay?
Thank you, Bruno.
I seek your comments if you've decided on something that would be appropriate for the parties involved.
Chair, we had a discussion about timelines, but it'll be a little bit dependent on the tribunal's decision as to whether the order suggested by Mr. Halpin is acceptable to you.
So we discussed it, and what's important for us is that you're in agreement. We think that absolutely that would work, and we look to you for what would be reasonable for timelines.
Great. Well, I can speak, I think, on behalf of what we discussed. What we'd suggested was that both appellants file within 2 weeks from tomorrow. I should open a calendar before I say that, just to give you a specific date. So that would be Friday, May 7th, if that's correct, all counsel. And so the two appellants would file on that date. And then the government of Nunavut would have also a 2-week period, which would bring us to first. And then if there's a need for QIA or BIMC to reply, we'd contemplated just an additional week. So that would be May 28th. And all councils agreeable to that.
Okay. Well, the panel members are in agreement with that too. And so I think we've got agreement on that matter. So I'm going to move into concluding remarks now. And I just wanted to say, you know, I think we can all be proud to accomplish something here. The hearing is not easy in person, and we've certainly done this one from Vancouver to Halifax to Ottawa, Toronto, Iqaluit, and Yellowknife. So I think I'm happy to have been a participant, and thank you very much for all your efforts. I've mentioned a few times during the last few days how impressed I've been and the panel's been with the quality of the work and your professionalism and expertise. And so to Jeff and Jessica and Aria, to Matthew and Jenna Ann, to Jane and Ryan, thank you very much for that. And thank you for our support staff. And just my formal remarks on behalf of the panel members, I'd like to thank counsel and their clients for the work and preparation which have gone into the public hearing. We all understand the importance of the issues which are presented, and as chair, I can assure you that the decision in these appeals will be taken by the 3 members of this panel. We expect to reserve judgment to deliberate and prepare a written decision as required by law. While I cannot say how long this will take, we will strive to complete our work expeditiously, having regard to the thousands of pages of documents in the record and the excellent presentations made by you all. The Tribunal would also like to thank the Zoom host, whose technical support has enabled us to conduct the hearings. The Tribunal would also like to thank its secretaries who have prepared minutes in the pre-hearing conference and who have presented documents in the Tribunal record for display during our proceedings. I want to say a word about the Tribunal record. Panel counsel has worked with counsel for the parties to digitize the Tribunal record and make a copy of the whole of it available to counsel via a secure digital FTP site. These have been updated this week as exhibits were entered. Our decision will be based upon the evidence in that record. And the record will, the record actually won't close at the conclusion of the proceedings until we get the final submissions. Finally, it's now customary for tribunals across Canada to recognize the Aboriginal lands on which the proceedings were held, and in our digital context, the panel wishes to recognize the Inuit people of Nunavut, on whose Inuit-owned lands Mary River Mine is located. If there's nothing else, then I would like to say thank you again, and this hearing is concluded.
Thank you very much.
Thank you all.
Thank you.
Clean the mic.
Clean the mic.